Talking away, I don't know what I'm to say, I'll say it anyway. Today's another day to find you shying away. I'll be coming for your love, okay? Take on me, take on me, take me on, take on me. I'll be gone in a day or two, in a day or two.
Welcome again, I'm David Gotch. I do appeals, I do commentaries on appeals, and that's about it for introductions because today is all about contempt. What's kind of neat about today is that I get to kind of briefly talk about an appeal I did that involves contempt. It's a citable opinion, so if you're curious about what that was, stay till the very end of the video. Turning back to our subject, what makes contempt interesting is that you won't find a statute that tells you what it is. It's a creature of case law and, tradition. Now, for those of you who are family law practitioners, the following animation is, well, it's merely review. For non-attorneys, excuse the poor quality. It's the best I can do.
For centuries, judges have had the inherent authority to enforce orders through a process called contempt. In Illinois, there are two kinds, criminal and civil. The primary determinant of whether contempt proceedings are civil or criminal is the purpose for which sanctions are imposed. If sanctions are imposed for coercive purposes, to compel the contemner to perform a particular act, the contempt is civil. On the other hand, criminal contempt sanctions are imposed for the purpose of punishing past misconduct. Civil contempt proceedings have two fundamental attributes. 1. The contemner must be capable of taking the action sought to be coerced. And 2. No further sanctions are imposed upon the contemner's compliance with the pertinent court order. In other words, the contemner must have an opportunity to purge themselves of contempt by complying with the pertinent court order. If the sanction is incarceration, the respondent's circumstances should be such that they may correctly be viewed as possessing the keys to his cell. Furthermore, civil and criminal contempt each have two subcategories. Direct or indirect. Direct contempt is contemptuous conduct which occurs in the presence of a judge. For example, outbursts during court or other disruptions of judicial proceedings. While in indirect cases, the judge does not have full personal knowledge of all elements of the contempt. Therefore, proof of facts of which the court cannot take judicial notice must be presented to support a finding of contempt.
As noted in the video thumbnail, I'm kind of sticking with indirect civil contempt, and I'm going to address it in these stages. So, without further ado, let's get to it. First is the order. Now, you do need a written order or a docket sheet entry, depending on the county. It's got to be something that clearly spells out in writing what the party is supposed to do. Now, when I say clear, it's so ridiculous that even a caveman could understand what the obligation is. You know, if the order says dad's supposed to get liberal visitation and mom isn't allowing it, now as bad as that might be, that's not enough for contempt. You really need specificity, dates and times, for example. Because the test is really, if I handed the order out to several strangers on the street, all of them are going to know exactly what's expected and the deadline to do it without a notable difference of opinion. Next is the petition, and local rules are going to vary on this, but your motion should state it's seeking a petition for rule to show cause or a petition for indirect civil contempt. One thing to keep in mind, a petition for rule is to enforce. Case law is very clear. You can't use it as a backdoor effort to modify or otherwise engraft new obligations or to otherwise seek compensatory damages as a result of the non-compliance. Next is the rule. Now, many local rules allow a rule to show cause to issue if the motion is verified, such as Will County, for example, while other counties make it discretionary. If a hearing is required, the inquiry is kind of limited. It's just to see whether or not an order might have been violated, and if so, the rule issues. Now from there, the burden shifts from the moving party to the alleged contemptor, and they have to show cause why they didn't violate the order, or that they did violate it but otherwise have a recognized defense. And the rule, well, it can issue in stanter or on another date. That's kind of situation depending. Now don't worry, I'm going to get to defenses here in just a moment, but first I want to back up and talk about our next thing, which is service. The petition is generally served the way we serve, well, any routine filings, but if the rule issues and the alleged contempt nor isn't in court, there are a couple tripwires you should be aware of. Generally, if the alleged contempt nor isn't in court when the rule issues and you're seeking contempt for non-child support issues and you're asking the judge for a body attachment or an order of incarceration, the law requires they be served pursuant to Rule 105 first or via personal service somehow, such as a sheriff or a special processor. Outside of that, though, email or a postage stamp noticing up the matter is really all you need. I graduated law school during the Great Recession, and really no one was hiring, so I kind of threw out my own shingle and took pretty much anything that walked through the door, and over half of those, well, they were dads facing contempt petitions, usually for non-payment of support, but sometimes parenting violations as well. Any defense that's allowed in equity is typically fair game in a contempt charge. Now, this isn't all the defenses, but I've included either the most common or the most interesting that you can deploy, and as a bonus, I'll cover a few that you can't use. The first is financial inability. The leading case is Deke, and it goes, something like this. If mom hauls you in for non-payment of support, and you're saying, hey, I got no money, that's a valid defense, but, and there's always a but, you gotta present to the judge an accounting of where all that money went with documentation. And you better not have spent it on Hulu or Netflix. Now, keep in mind that even if your client, if he's like flat broke, if that was a result of, say, giving the money to their brother or family member to avoid paying the child support, the defense is going to fail. The next one's impossibility, and here's kind of an easy scenario. Let's say your client's supposed to drop off the kids at 6 p.m. on Friday, but 20 feet of snow comes out of nowhere. Governor declares a state of emergency, bars, road travel, except for emergency personnel. In this case, it's impossible for mom to comply. The next one is a bit confusing. It's called equitable estoppel. To raise equitable estoppel as a valid defense to contempt, all 6 elements to it have to be met, and I'm just going to list them here very briefly. Feel free to pause the video if you want to write it all down, because it kind of dovetails into the next one, which is unclean hands, and this is a very similar doctrine. It's almost a distinction without a difference, but not quite. I like to look at unclean hands as direct misconduct that excuses noncompliance. Estoppel might be mom going to dad with an out-of-court deal regarding child support, dad paying it per that agreement, then 10 years later, mom files for contempt for the difference of what was actually required in the order. Dad might still owe, actually he does pursuant to this case, but it's not contemptuous because he relied upon mom's misrepresentation. Whereas unclean hands, well, that might be that mom starts a fight at the pickup and drop off. Dad leaves with the kid to kind of get away from the situation, but since she missed her parenting time, she's trying to hold dad in contempt. So you can kind of think of the former as maybe sucking dad in for a con, and the latter as acting like a bull in a china shop, if that helps. The next is friendly contempt. Friendly contempt exists. I swear it does, but it's not really a defense per se. It's really a challenge to the court's authority to enter the order. Essentially, the judge orders something that you're not entirely sure they can order because there's no precise case on point that discusses it. So you openly violate it, which allows you to then take an immediate appeal. But friendly contempt is not resisting an order because you feel like it. A great example of unfriendly contempt is this one right here. Apologies to Judge Bose. Now, for those that like Aflac trivia, the following cannot be used as an affirmative defense to contempt. First is statute of limitations. Technically, there is no statute of limitations to contempt, but latches might still apply, and latches is where you waited 30 years to seek contempt for unpaid support, and whatever payment records that might have existed, well, they're kind of long gone, and dad can't defend himself. Another one is lack of verification in the motion or petition. If the motion for contempt isn't verified, well, oh well, so sorry, so sad. It's actually not a raisable defense. Another one is uncertainty, and that's where you're not sure how much you owe. Not because of a vague order, but because, well, you're kind of a lousy bookkeeper. That defense has been tried, as noted in this case, and it doesn't fly. So if the defenses fail, the client can be found in contempt, which is sort of like saying water is wet. But I'm mentioning this because there's actually some case law that suggests that even if they have your client dead to rights on a contempt charge, the court should not impose contempt if, keyword if, there's no other remedy available. Now we move on to the sanction. All civil contempt findings require a sanction, and all sanctions are temporary because once you comply, the sanction must cease. Sanctions, commonly like jail, well, they can be indefinite, but there are some time limits, such as child support, which is capped at 6 months of incarceration. Furthermore, if the client is telling the judge they would rather, die in prison than comply, technically, they're not supposed to turn that sanction into a de facto life sentence. Now, with the sanction, there must be something that the contemptor can do to discharge it, i.e., we call it the purge. And you hear judges say some variation of, hey, counselor, I'd love to lock up your client forever, but I have to give him the keys to his cell. No purge means it's not a valid contempt finding. And finally, we get to my favorite part, which is the appeal. Contempt is immediately appealable under Rule 304b-5, provided the court has imposed a monetary or other penalty, such as, jail. If the penalty is money, that amount must be an ascertainable sum. Without it, the court can't review the finding. Sorta. In the last few years, the appellate courts have carved out an exception to this. 2 cases in particular, In re AM out of the 4th and In re Marriage of Virgin, which I was the attorney that handled that one last spring. And in Virgin, the contempt finding against my client didn't impose a sanction, but the case suddenly concluded and there was no additional court dates. So mom's lawyer says, hey, no penalty, no jurisdiction, you can't review it. Whereas I cited the AM case stating that it should be reviewable under Rule 303 because otherwise the faulty contempt escapes any review. And the 3rd district said, hey, we're going to join the 4th, and a defective contempt that otherwise can't be reviewed under Rule 304b-5 is reviewable as a final judgment under Rule 303. And there's my tiny contribution to contempt case law. So as we wrap things up, no video this short can tell you everything you need to know about contempt, but I hope I provided kind of a general overview of at least the big ticket issues that commonly arise. And if you stay through the credits, I'm going to list some case citations that you might find useful in your practice. So there you go. Anyways, that's all I have as always. Thanks for watching.